Good afternoon. I'd like to call this public hearing to order. I have a couple of folks who have signed up to testify before the committee. Beginning, well, actually, let me just make sure. Any comments from my co-chair ranking members, and seeing none. Beginning with Bob Shea, from the Office of the Claims Commissioner. He is the Claims Commissioner. Welcome.
Good afternoon, everyone. My name is Robert Shea from the Claims Commissioner's Office. Thank you very much for inviting me to testify today. And I also want to thank this committee for your support in May for me to get this wonderful, important job. I thank Governor Lamont for appointing me. I'm here to answer any and all questions you folks may have.
Thank you. Are there questions for the Claims Commissioner? Senator Kissel.
Thank you very much, Robert. Bobby Shea, our Claims Commissioner. Mr. Commissioner, great to see you. I know you have been working tirelessly. Appreciate the fact that you circle back with members of this committee on the work that you've done since you've taken over. And I just applaud you and all the magistrates and other folks in your office for all the hard work that they've done. It really, really is for the benefit of the people of the state of Connecticut. Of all these claims that we have before us this afternoon, and I want to thank Melanie Dykes, Crack, legal counsel for Senate Republicans. The very last matter that we have on our agenda, PCOR, was handled in your office by our mutual good friend, Ed McEnany.
That's right.
Who you know is a friend of mine and constituent. And I understand that the underlying, and this is a wrongful incarceration matter, certainly not as stark and troublesome as the matter that we heard from the Attorney General's office this morning. But in this one, ultimately was determined that about 1 year, this individual, Mr. Pecor, served in prison. And so there's sort of a statutory formula for the compensation for that. But then there was another, I think it was about 7 months with an ankle bracelet. Now, I believe that we have a bill that we raised at the request of one of my constituents, although I can't say at this point in time that I'm 100% in favor of the bill itself, although it's an interesting question that it raises as to whether, for example, house arrest or having an ankle bracelet rises to the level of loss of so much freedom that it should be equated with being in prison. But in this matter, the compensation as it was determined made it the same. And so either we have a gray area in our statutes such that Attorney McEnany determined that the compensation should be the same for the time with the ankle bracelet as well as the time in prison. From my just human gut reaction, hey, give me an ankle bracelet any day and let me live my life, as opposed to put me in McDougall Walker or something like that. And so I'm just wondering what your take is on this, if it's your reading as the commissioner that it is a gray area, and would it be an area that we would have an ability to sort of sever those two things? Because I have a real problem supporting an award where those two things are equal. And I also have a problem with the underlying case as it is, but that's a whole separate story. So that's my question, Mr. Commissioner.
Thank you, Senator. I'm looking at Attorney McEnany's decision, and he does recognize that distinction. I'm looking at the bottom of the second page. He says, while the amount of time that Mr. Pecor spent in prison is either a year or a year and 7 months, he decided to select the 1 year and 7 months. So I think he did the hearing, and I think for reasons of justice and equity, he thought that Mr. Pecor should be entitled to the 7 months that he was wearing an ankle bracelet. But I see your point. I think that is an issue for this committee to address. What type of incarceration or penalty would qualify for compensation. So it's a fair point.
Okay, so that with that stated, I'm going to now ask direction from the chairs. Uh, I don't know what latitude we have right now this afternoon as far as perhaps bifurcating this particular award. I don't feel comfortable awarding someone the same for wearing an ankle bracelet, lawful or unlawful, as being falsely incarcerated in one of our correctional facilities. And I don't know if we need to defer at this time to LCO, if this is not the right time. We wait to all the people that come before us that have signed up to speak. I'm just sort of in sort of new territory, Mr. Chair.
Co-chair Stafford.
Thank you, Mr. Chairman. To the good ranking member, this is just a public hearing. We are not voting on these bills today. We're hearing on these resolutions, and we will take this up for a vote during our draft week.
Senator Kissel.
Thank you very much. I appreciate that. So I guess, Mr. Commissioner, I would ask this. As our boss when it comes to all these claims, and I know that you've had input on making sure that we have a better formula when it comes to a lot of these claims. Do you have an opinion one way or another as to whether we should equate financially dollar for dollar if someone has unlawfully been ordered to wear an ankle bracelet and with the concomitant monitoring that entails, make that equal with being incarcerated in a correctional facility where you are required to eat at certain times and you go to bed in a cell, whether it's dormitory style or 2 individuals per cell. Should they be compensated the same, in your opinion?
Thank you, Senator. Respectfully, I don't have an opinion at this time. I mean, I'd like to be able to do some research and some thinking about what exactly, how incarceration is defined or what it's considered. Certainly, I believe this gentleman was still under the authority of the Department of Correction, but I'm not sure what the limits are of what incarceration means. So I certainly will do some research and follow up to you about what I think. And then it's ultimately, I think, the Judiciary Committee's decision how to handle this. I think you're my superiors, actually. I think instead of it, I think you said maybe the other way around.
I very much appreciate that, Commissioner Shea. I think you've done an outstanding job. It is a decision that will be wrestled with, I believe, by members of this committee and the legislature as a whole. Ultimately, a majority of individuals will either decide to leave it alone or make some modifications. But I appreciate all your effort and the fact that we have such a large number of resolutions and claims that have reached conclusion before us speaks volumes in your favor as far as the hard work and diligence that you're doing. So thank you so much. And thank you, Mr. Chair.
Thank you. Next, we'll hear from Representative Fishbein, followed by Representative O'Day.
Thank you, Mr. Chairman. Hey, Bob, nice to see you. Bob, I want to go through the agenda because this is your opportunity. Item number 1, House Joint Resolution 21 having to do with Christopher Gaskin. Why is that matter before us here today?
Thank you, Rep. Fishbein. That matter was decided pursuant to Connecticut General Statute, Section 54-102 UU, which under subsection D1 requires certain decisions of the Claims Commissioner's office to be sent to the General Assembly for review.
Okay.
And then there was an award made in this claim of approximately $674,000 by me in our office. So we sent it up here for review.
And is that based upon a statutory calculation, or was that an arbitrary amount that your office determined?
It was based on a statutory calculation, excuse me. And it was information that was submitted to me by Mr. Gaskin's attorney, Sean Fisher, who I believe is here today, as well as the Attorney General's office. So I took the information they submitted about the calculation and I made a decision how much to award. And I set forth the basis for my calculations in the written decision on this claim.
Okay, so it's in excess of $600,000. And how long did Mr. Gaskin serve, if you recall?
Well, that's part of the issue in this claim. He he had served 19 years for the convictions that were ultimately vacated. But at the same time, he was serving for other convictions for approximately 14 years. So what I decided to do was award him for about 5 years of compensation.
And in that matter, is there any contest as to the amount?
I believe there is. I believe Mr. Fisher would contest the amount, and I don't know if the AG's office is contesting it, but I believe there is contest on the amount that our office awarded.
Okay, and I'm sure we'll get to that.
Right.
And your position is that you did the proper calculation and that your determination was in line with case law and statute.
Yes, I mean, I'd be honest with you, I think my decision is controversial because I did not award the amount for the entire 19 years that Mr. Gaskin spent incarcerated for this particular conviction. I did deduct for the years he was incarcerated for other convictions.
Okay,
So it is controversial.
So, and I want to try and help the process because this is your opportunity. And if you anticipate that we're going to hear an argument from someone else saying that you did something wrong, I think it would be helpful if maybe you explain why you did what you did.
Thank you very much for that, too. I just believe that if the concept of wrongful incarceration for Mr. Gaskin was approximately 5 years, not the entire 19 years. That was my decision.
Okay, and I don't want to, I just want to give you the opportunity.
Sure.
Because, you know, procedurally, you're not going to be able to come back and retort without some sort of, you know, changing of the rules.
That was probably essentially the basis for my decision, Rep. Fishbein.
Okay,
Just
so
simply that, yes.
generally, the gentleman served 19 years, but it's your legal opinion, based upon your analysis of the case, that the actual impact was 5 years because he was not exonerated of these other charges that he would have had to serve for anyway.
Right.
Okay,
That was my opinion. It was partially a justice and equity decision too, not strictly legal. I mean, the statute frankly doesn't say that I can do that, but I did respectfully, but certainly the Judiciary Committee can decide to do otherwise.
okay. So then, the next item, House Joint Resolution 22 has to do with Ronnie Ellis.
Yes.
And how much did, sort of the same situation, you made a determination, and how much is that award for?
$1,310.
Okay, and how or why does that one, which is a small amount, come before us here today?
The reason I requested that the Judiciary Committee review this claim is because it was decided, I believe, on February 2nd, 5 days before the legislative session began. Mr. Ellis would not have had the opportunity to request an appeal for 20 days. So to be fair to Mr. Ellis, you know, so he would have a chance to review it, I sent it up here.
So has Mr. Ellis expressed opposition to your amount?
I don't believe so. Mr. Ellis is represented by attorneys, so I told them I was sending it up here, and I also sent them notice of this hearing today. I don't know if they're here to speak, but that.
Okay, once again, you know, if you had that knowledge, just trying to give you the opportunity
Yeah.
to, you know,
Yeah.
state your case.
Well, so the dispute in this claim was frankly, the original claim was seeking 19 days of incarceration. And this was incarceration based on credit calculations at the end of Mr. Ellis's sentence. And the evidence to Attorney McEnany, who did this claim as well, and to, which I support, looked like the evidence showed that he had spent 4 extra days incarcerated. So we awarded 4 days based on the HUD figure for how much a median income is. So calculated to $1,310.
But at the end of the day, due process, you have given notice. If nobody appears today, your decision would stand.
Well, I suppose that's up to this committee. You may certainly disagree with our
Sure.
decision, but yeah.
So then we have 209 91 resolutions that follow that one, which appear all to be requests by your office for extensions of the time to resolve a claim.
Yes.
So I think it would be appropriate, I'd like to know at least, why you're looking for those extensions. And hopefully it's for one reason. Not
Well, to
291.
be honest with you, I didn't get to work on these claims. I mean, and it's so, I would like the opportunity to work on these claims. We have a good system in place that we're very proud of to resolve claims, very quickly. I think, the real secret relates to two young gentlemen sitting behind me. We brought in 5 interns, this semester. Ryan is a lieutenant in the United States Army, and he is hoping to go to UConn Law School in the fall. Dave is in the Manchester Community College Paralegal Program, which is an awesome program. And we have 3 other interns that are really helping us. We get a mountain of paperwork in every day, on our claims, and they're helping us get the paperwork into our system so we can get these claims ready for decision.
And then based upon the claims that you're getting in, I mean, one cannot forecast what the next year brings, but I understand that, you're dealing with, you walked into an office with a lot of files that you're having to triage and deal with. Do we expect the same situation next year? God willing that I'm here.
Yeah, me too. Yeah. I mean, God willing, we're both there.
But
But
you have a
yeah,
longer term than I do.
yeah. So, well, the fact, it's a good question. I appreciate it. I mean, we get, we did some analysis from January of 2023 till the end of January 2024, last month. We've got 410 new claims filed. So as we're working on the current claims, we're getting new claims filed. So, and last year we resolved 482 claims. So, it's hard to get, with the current situation, it will be hard to, beat those odds a little bit, but I think we will beat them because we have a streamlined process. We have these awesome people helping us. We have, I have 2 paralegals, Tara and Erica, who work like maniacs. They're very committed to the Claims Commissioner's office and the people of Connecticut. And we have 5 part-time magistrates, including Mr. McInerney. So I think we will make more headway. And other good news is Governor Lamont put in funding for another full-time paralegal for our office. Hopefully, if that passes in the budget, we'll have another paralegal this summer.
You're still utilizing the deputies.
Yes, very actively, yes.
And, interns are temporary.
Yes,
So turnover may affect the ability going forward.
yeah, well,
Are you asking for more?
well, the
permanent
good news
staff?
is the word's on the street, and maybe Ryan and Dave are doing it, but the good news is that people are saying that the Claims Commissioner's office is a fun place to work. So I've already heard from several applicants to be interns this summer. It's really good news.
Good.
So, yeah, so turnover is an issue, but I think we're going to have good young people from our public institutions of higher ed who are committed to helping out the state of Connecticut to come in and help us out. So I'm very, very positive about the future.
Okay.
And frankly, I know there's people from the Attorney General's office here. They've been very cooperative and very helpful to help streamline the process and make sure that we're getting these claims ready for decision as quickly as possible.
I think I owe Ryan a call and he will get
Yeah,
it.
he happens to live in your district.
I
yeah.
know.
And by the way, Dave lives in Enfield, Senator Kissel. So, yeah.
Yeah.
Um,
The last 2 on our agenda, resolution 150 has to do with the claim of Leroy Harris.
yes,
And how much was that award for?
$7,500,000.
And how does, or why does that come before us here today?
I believe under 54-102 UUD1, because it's a large award issued by the Claims Commissioner's office, it's required to be reviewed by the General Assembly.
And is there a contest as to the amount on that one?
I don't believe there is. The Attorney General's office is here in case you have questions, but that was a stipulated agreement entered between Mr. Harris's counsel and assistant AGs.
Okay. And
It was
Are-
29 years of, approximately 29 or 30 years of incarceration.
And that was a DNA case? DNA exonerated Mr. Harris?
Is that DNA? Yeah. In part, yes.
Yeah, okay.
I didn't want to speak out of turn, the folks that. did the
Well, because,
negotiation.
my review, once again, it's another contract lawyer who, ineffective assistance of counsel. We had the same issue last year when we had the case about the DCF where they put the child in somebody else's care, and there was a contract lawyer, appointed by the juvenile court whenever everyone went to see the kid, and then the child ends up with 2 broken legs. So, more and more my eyes are getting opened as to the system. And I don't know what we do, but anyway, the last one, 151, case of Gary Pecor. What was that amount for?
143,000. That's the one that Senator Kissel was just inquiring about.
And why does that one come before us?
Under section 54-102 UUD1, it's an award that is above $20,000, so it needs to be reviewed by the General Assembly.
Okay, and it's more like an FYI sort of thing.
Well, I think the General Assembly can decide whether or not to support or amend these awards. I think that's in your review power.
And is there a contest as to that award?
I don't know. I don't want to speak for the Attorney General's office. I mean, there was a hearing on this case, and Attorney McEnany made a decision based on the evidence in the hearing.
Because
So-
certainly there's cases that come before us because the statute says they have to come before us.
Right.
And, that's one thing, but, there's additional eyes on a case that there's actually a contest that we're gonna have an argument on the other side. So once again, I mean.
Yeah, so that's a good point. I don't know if 54-102 UU, I don't think it distinguishes between cases that are contested or stipulated agreements.
Agreed. And I'm
yeah.
just trying, this is a public hearing, so.
Oh, right, I get you.
Essentially, you are in effect arguing to us why you did what was right.
Did what our office believed was right, yes, yeah.
Yeah, and because I don't know if somebody else is gonna say what you did was wrong and we should, and then give you an opportunity to defend. So, as we work through this process, perhaps we deal with those issues on a different plane, but I thank you for coming here today. I thank you for the opportunity, and thank you, Mr. Chairman.
Thank you, Representative. Representative O'Dea.
Thank you very much, Mr. Chairman. Good to see you up there, Commissioner.
Thank you.
So I can understand, just as you know, history. I'm not sure many in the audience know it as well as we all do, but there had been a backlog of claims at the Claims Commissioner Office, and you came in and, from my understanding, have done a really good job of organizing, streamlining the process. Can you tell us, last year you resolved 482 claims and got 410 new claims, from what I just understand.
Right.
So the number of claims when you got there were how many, if you remember?
I think it was
no?
about 700,
Okay,
which is what we have today.
all right.
So,
Well, we cleared out, by my math, which everyone who may pay attention at these meetings knows my math is not my best suit. I've never been on finance or ropes for a reason.
you're a man of letters.
If my math's correct, you basically reduced the number of pending claims by 72. If you brought in 410 new claims last year and resolved 482, my
That's
math
right.
says there were 72 cleared out.
That's right, which is not enough.
Correct. So I guess my question is, in addition to the interns we're talking about and staff for another paralegal, are you hopeful to make a bigger dent in the pending claims than the 72 you were able to do this year?
I am Repo Day, and to be honest with you, I've been on the job 10 months today,
Yeah.
and I spent several months just trying to figure out what to do and talking with my colleagues, talking with people in this committee. And now I feel like I have my sea legs and I have really good people working with us. And I think, like, and I said, the Attorney General's office is being super cooperative. So is the claimants bar, and so are the claimants that are pro se. So I think we can get many more claims resolved, but I hope, maybe the net positive in 2024 will be plus 200 instead of plus 72.
Got it. And you've only been there for 10 months, and I get it. And I've got
Did I say 10 months or 10 years?
yeah,
Oh,
dog
I meant
ears
it's
almost,
10
but
months.
no, we have the utmost confidence in you. I was happy when you stepped the plate and were appointed by the governor. So I'm looking forward to seeing more progress as time goes on. And you haven't even been there a year yet. So I thank you for your hard effort and those in your agency there and your interns. Thank you for helping out.
They're the secret weapons, frankly. The interns are great people. Yeah,
And they're unpaid interns, right?
they're unpaid. They work very hard. The benefit is they get academic credit.
And I'll move to double their current salary
Yeah.
at the next
Put that
budget
in the
meeting.
budget, right?
Yeah. But anyway, no, thank you very much, Commissioner.
Thank
Thank
you.
you, Mr. Chair.
Thank you, Rep. Bode. Very generous. Comment or question from other members of the committee? Comment or question? Seeing none, Mr. Commissioner, thank you very much for joining us. And as has been said by all of the other members, thank you very much for the work you're doing. It has been something we've needed for a very long time, and we appreciate your dedication.
Yeah, I'm honored for your support, and thank you.
Thank you. We will next hear online from Alex Thomas. Is he here? I don't see Alex, so we will go to Devon Ward. Good afternoon, Attorney Ward. Let me sit down, make sure you push the button to turn on the microphone, and you have your 3 minutes to testify.
Thank you for reminding me. It's been a bit since I've been in front of the legislature.
Gotcha.
Thank you for allowing me to speak today. My name is Attorney Devon Ward, and I'm here to testify regarding HJ 92, a resolution granting the Claims Commissioner an extension to dispose of the claim of Tylon Edwards. Tylon Edwards, a resident of New Haven, Connecticut, was a prisoner with Connecticut Department of Correction and spent 13 months in solitary confinement at Manson Youth Institute as a child. Mr. Edwards was born in June of 2001. The DOC held him in conditions of near total isolation for 23 to 24 hours a day from April 2018 to May of 2019. The Connecticut Office of the Child Advocate published a report on the inhumane and demoralizing conditions at NYI that DOC subjected minors like Mr. Edwards to from February through November of 2019. During the same period, 18 boys were subjected to a chemical agent during 11 instances. Several boys subjected to chemical agent were also boys with psychiatric and disabilities and or asthma. The United States Department of Justice also investigated NYI and concluded that there is reasonable cause to believe that Manson's isolation practices and inadequate mental health services seriously harm children under 18 and place them at substantial risk of serious harm. In addition, Manson fails to provide adequate special education services to children with disabilities. These violations are pursuant to a pattern or practice of resistance to full enjoyment of rights protected by the Constitution and federal law. These conditions also suggest flagrant violations of Connecticut's Constitution and state law that guarantee free public and secondary education to all school-age children in Connecticut. DOC subjected Mr. Edwards to many of the horrendous practices and conditions identified by the Office of the Child Advocate and the DOJ. Excerpts of the reports are attached to my testimony. You can also review the reports in their entirety online. With the assistance of co-counsel Kenneth Krajewski, on August 10th, 2020, Mr. Edwards filed his original claim with the Claims Commissioner indicating the statute of limitations on this matter had been extended by the COVID executive orders of Governor Lamont and by the rules of the Claims Commissioner itself. Mr. Edwards' claim has now been pending with the Claims Commission for nearly 4 years. He is a young man that prays for his opportunity to have a court of law hear his claims about the unlawful acts committed against him. It is with that hope that we respectfully request that the committee amend HJ 92 to grant Mr. Edwards permission to sue the state of Connecticut Department of Correction for prison negligence. I've attached substitute resolution to my testimony. thank you for your time and attention. I'm available to answer any questions that the committee may have.
Thank you, Attorney Ward. Comment or question from members of the committee, Representative Fishbach.
Thank you, Mr. Chairman. Good afternoon, Attorney Ward.
Good afternoon.
In our state constitution, there's a prohibition on public emoluments. How, if this committee was to give your particular client a leg up or a place that the others don't have to follow, how would we fashion what we would have to do to get out of the potential claim by the Attorney General's office that it would be a public emolument?
I don't believe it would be a public annulment in that you're not granting a special right to Mr. Edwards to be able to sue. I mean, this is the process contemplated by statute and is within the General Assembly's right to be able to allow Mr. Edwards to proceed to court for these claims.
So a public emolument, and I don't mean to put you on the spot.
Sure.
Right, but this is what I wrestle with. So a public emolument is where an individual is given some benefit that the general public doesn't have, right?
Correct.
So by giving the right to sue, in all sympathy to your client's situation,
Sure.
we would be saying to your particular client, we're going to open the gates for you to go to court, whereas the others that are similarly situated are not going to get that benefit. And the problem that you have, I think procedurally, is if we did what you're asking us for, then the Attorney General's office is going to file a motion to dismiss as soon as you bring your claim. And I believe there's cases out there where they were successful in getting the case dismissed. So then where are you?
So I don't see the issue of it being an annulment designated specifically for my client. You know, this committee has extended the ability to sue to several individuals under similar circumstances in the past, and that argument hasn't been raised by the Attorney General. In fact, I'm litigating a claim where you all gave permission to sue to a woman who died from alcohol overdose in DOC custody in 2018 right now. And we're litigating under a negligence standard through the ability that this committee gave my client to sue the state under a negligence standard. So I don't see how this would be conferring a individual benefit that no other resident has. Any resident can petition the claims commissioner and certainly seek the same ability to be able to sue. You're not extending the statute of limitations. You're not conferring any particular benefit that's not available to anyone else under the Connecticut General Statute to my client. So I guess I'm not exactly following how this would be a specific annulment specific to my client.
So can we talk about that other case that you were just referring to?
Sure, certainly.
So in that particular case, and I don't know what case it is, but I'm
Sure.
certainly been involved in this system for a while.
You voted on it.
Okay.
Yes, sir.
Yeah, that would have been the ultimate.
Sure.
But in that particular case, didn't the claims commissioner like do something with the file? Did they reviewed the file? They made a determination whether or not there could be a claim against the state. Perhaps they dismissed the claim, and then it came to us, and we may have overturned the decision of the claims commissioner and given the permission to sue. Is that what happened in that case?
I think I'm seeing your point. Actually, in the case that I mentioned, the client was allowed to sue pursuant to statute, which allows claims of medical malpractice to proceed directly if they attach an opinion letter.
So that's
It's so
and I appreciate the exchange,
Sure.
right? But that's sort of what I'm wrestling with is, skipping up in line, because I'm aware of many cases that we've done with incarcerated individuals where the claims commissioner we felt has made the wrong decision. And we've overturned and we've said, go to court. But I'm also aware of cases before I even got here where the legislature said, go to court, and the case was dismissed.
Mhm.
And then that person who should get remedy is left with nothing. And that is a travesty of justice in my opinion. So I'm just trying, sometimes we get people who ask for these things or ask us to do something, and I just want to, you're sitting here on behalf of your client.
Yes, sir.
And if at the end of the day, you may end up with an empty bag, I'm just a little concerned, and it's the public emolument portion of our Constitution that is ringing in my ear, so.
Certainly, I do think there is case law on this particular issue. I have not had the opportunity to research it, but can certainly follow up with you in the committee regarding that concern.
Okay, well, I thank you for the exchange, and thank you, Mr. Chairman.
Thank you.
Thank you, Representative Fishbein. Is there a comment or question from members of the committee? Comment or question? I don't see any, so Attorney Ward, I want to thank you for joining us again and the work you've done on the behalf of many of the people who've been incarcerated in our state. Thank you.
Thank you.
Attorney Fisher, Sean Fisher. Make sure your microphone's on and you have your 3 minutes.
Thank you, Chairman. My name is Sean Fisher, and I'm from the law firm of Brenner, Salzman, and Wallman, LLP. I'm here as counsel to Christopher N. Gaskin, who is a claimant in a proceeding before the Claims Commissioner. I submitted written testimony, and what follows is a brief summary thereof. My client, Christopher Gaskin, the claimant in this Claims Commission matter, suffered a terrible wrong. His only hope to right that wrong is compensation for wrongful incarceration, compensation that this General Assembly provided in Section 54-102 UU of the General Statutes. My client's loss is the result of the state's misconduct. Because of the state's misconduct, not disputed before the Commissioner, Mr. Gaskin was wrongfully convicted of murder and sentenced to life or 60 years in prison. There was no parole, no sentence reduction, no hope. In 2018, after about 13 years, the appellate court overturned that murder conviction. The appellate court found serious constitutional violations involving the prosecutor's failure to correct the star witness's lies and outright reliance on those lies. There was no retrial. Mr. Gaskin left prison as a result in March of 2019, but the damage had been done to him. Mr. Gaskin respectfully disagrees with the Claims Commissioner's award from October of 2023 because it does not go far enough under the statute. The statute, as most recently revised, provides for an award of a predetermined amount for each year such person was incarcerated. The statute says nothing about other concurrent sentences during the period of incarceration, thereby reflecting this General Assembly's choice to not consider any such sentences in an award. Therefore, no periods of time should be excluded in calculating an award. In the award to Mr. Gaskin, the Commissioner excluded periods of time for concurrent sentences. Those periods should not have been excluded because the statute does not say those periods should be excluded. As such, the award should compensate Mr. Gaskin for the entire 17.5 years of the life sentence he served, regardless of other sentences. The award should be modified and increased within the statutory range for the entire 17.5 year period to an amount not more than $4,525,825, which is 225% of the statutory calculation, the maximum permitted by the statutory range, and not less than $2,011,478, which is 100% of the statutory calculation. In the alternative, if the General Assembly agrees with the decision or the award of the Claims Commissioner, the award should still be modified. If the ability to exclude time periods due to concurrent sentences is authorized by Section 54-102 UU, then the ability to count for any consequences caused by the wrongful conviction must follow. In other words, if the wrongful conviction caused a claimant to serve other sentences or lengthened a concurrent sentence, then those sentences should not be excluded from the award. Here, because of the wrongful conviction, Mr. Gaskin served time on an assault charge based upon the same circumstances and evidence as the vacated murder charge. That concurrent sentence is a result of the vacated murder charge. If there was insufficient evidence to convict Mr. Gaskin on the murder charge, then a corresponding lack of evidence necessarily exists on the assault charge. Therefore, time Mr. Gaskin served on that assault charge should not be excluded from the award calculation. As such, in the alternative, the award should be modified and increased in an amount of the original award, which is $674,45.25, plus an amount not more than $1,177,257.98, which is 225% of the statutory calculation for the period claimant was incarcerated solely on the assault charge, which again is the maximum range set forth in the statute, and not less than $523,225.77, which is 100% of the statutory calculation for such period. Thank you for the opportunity to speak before you today.
Thank you very much. Comment or question from members of the committee, Representative Fishbaum.
Thank you, Mr. Chairman. Good afternoon, Attorney Fisher. The underlying theory of law that we're dealing with here, and please correct me if I'm wrong, is essentially but for the wrongful incarceration, there would not be an award. Would you agree with that?
I would agree that that's the alternative argument I'm making. I would disagree in the first instance because I believe the statute doesn't provide for any reductions based on concurrent sentences.
But we wouldn't be here at all, but for the wrongful incarceration.
I do agree that there has to be a wrongful incarceration for there to be a claim under the statute.
So the assault charge, was that vacated?
No,
So we're merely here because of the vacating of the murder charge, correct?
yes, I said murder. It's murder and conspiracy to commit murder, but you are correct.
Yeah, the two are merged together. So, but for the wrongful conviction, there still would have been time served. Correct?
I would phrase it differently. There has been a wrongful conviction and there was time served based on that wrongful conviction. And therefore the statutory remedy is triggered.
Yeah, but there would have been, if the process was pure and we got it right the first time and there was not a conviction for murder and conspiracy, this individual still would have served time on other stuff, the assault, for instance.
I don't think the assault, let's leave that aside, but the answer is that yes, there was time that this individual, that Mr. Gaskin would have served had there been no murder conviction.
Okay, and the assault conviction stands because that wasn't vacated by the process, right?
The opportunity to vacate that charge didn't arise until that sentence had already terminated.
Okay, I suppose, and I don't know if it's possible to go back and make that argument to the powers that be, but that still hasn't happened. So in the purest form, isn't that what we're left with? The difference between getting it right the first time and what would have been served?
I agree that if one looks at the statute as the commissioner did and reasons that the statute does provide for, or does ask the commissioner to look at concurrent sentences, again, which is contrary to the position I'm taking, then I believe there is a but-for element.
Okay, well, I thank you. Thank you for the exchange. Thank you.
Thank you, Representative Fishbein.
Representative Stafford.
Thank you, Mr. Chair. Thank you, Attorney Fisher, for being with us. So this might be an unfair question to you, frankly, but I think it's one we as a committee have to ask, which is what is our standard of review here? I mean, the statute is vague. The statute says awards need to be submitted to us. But essentially what you're asking this committee is to input our subjective judgment or that of the claims commissioner. And I guess I'm reticent to do that. That we delegate what in some states, frankly, is a legislative prerogative of waiving sovereign immunity or frankly, making these types of awards. We delegate that responsibility to the claims commissioner. So I guess when I hear these, or when I review these, I look for something that the claims commissioner got manifestly wrong, right? If it's a flip of a coin and the claims commissioner could be right on their interpretation of the law, I think it's the better part of valor for us to defer to the judgment of the claims commissioner, who was frankly the trial level hearer of the facts here. Convince me I'm wrong on that, or why this case sort of stands out as something that would be the claims commissioner got manifestly wrong.
Thank you. And my response would be that the General Assembly has the ultimate say over what's just and reasonable with respect to these awards. And I would respond to you and say that's the standard that this General Assembly would apply. Now, as far as what that means in practicality and how you view your role in these proceedings in light of the commissioner's decision, I will tell you that this claim is different and deserves treatment from, or deserves consideration from the General Assembly, because I believe that the statute wasn't properly applied. I respectfully disagree with the commissioner. The statute doesn't say that other sentences should be taken into account. The commissioner testified earlier that he did so, and he understands that that might be controversial, and that he did so with respect to considerations of justice and equity. And the points that I'm raising before the General Assembly are strictly limited to what I believe is an award, or to render an award that is true to what the statute says. And I limited the grounds raised in front of the General Assembly to those only. I'm not quarreling here with the commissioner's decisions on other aspects, or ultimately things that I view that are within his discretion. All I'm doing is asking the legislature to enforce the statute as written, as I see it.
Thank you.
Thank you.
Thank you. Representative Blumenthal.
Thank you, Mr. Chair. Thank you for the opportunity today. I have a question that fire today. The client's line of questioning, is it your position that statute does not require something from
Representative Blumenthal, I don't know if you can do anything about this, but you're coming across very choppy. It's very difficult to understand you.
sorry, I probably talk fast. So
That's not better.
how about this?
Try again.
All right, I'll try one more time, and if not,
That's
we
good.
can. All right, great. Apologies for my tech issues. So I wanted to ask a question that puts a little bit of a finer point on Representative Fishbein's line of questioning, which is it your position that the statute does not require proof of causation?
It's my position that the statute doesn't say how to treat concurrent sentences at all. So therefore, it's really not a causation issue. Once a claimant establishes eligibility under the statute, then the claimant is entitled to relief.
Right, but isn't the question here what relief exactly?
The question is how to make a calculation once eligibility has been established.
But it's your position that there need not be but-for causation for a specific award. No causation link between the wrongful conviction or the conduct leading to the wrongful conviction and the specific calculation of the award.
My position is, as long as there's eligibility under the statute, which is that someone has been wrongfully convicted and has served time pursuant to that conviction and been released, then the person's entitled to some measure of compensation.
Okay, and a follow-up question, mostly for my curiosity. Was there a finding in the proceeding that vacated your client's conviction that the prosecutor was aware at the time the testimony was given that the witness was lying?
Yes.
Okay. Thank you very much, sir. And those are the extent of my questions. Thanks, Mr. Chair.
Thank you, Representative. Comment or question from other members of the committee? Representative Osborne.
Thank you, Mr. Chair. Now, just to recap, to make sure I understand your position. So your position is that the concurrent sentence should not be taken into account on the award in this instance because it stemmed from the same fact pattern as the life sentence fact pattern. Is that correct?
That is my alternate position, yes.
So playing hypotheticals here, if there were a concurrent sentence that were running for some unrelated or different set of fact patterns, would it be your position that even that concurrent sentence should not have an impact?
My first position is, to answer to your question with respect to my first position, which is that the statute doesn't deal at all with how to treat concurrent sentences, then my answer would be yes. No concurrent sentence, regardless of the circumstances, should be considered.
So if somebody is in jail for committing a burglary on East Street, and at the same time they are serving a concurrent sentence for a disorderly that happened on Violet Street, that concurrent sentence for the Violet Street crime should not impact anything with respect to the initial burglary sentence we're talking about. That's your position?
That's the way the statute is written, yes.
Thank you very much. Thank you, Mr. Chair.
Thank you, Representative Osborne. Comment or question from other members of the committee? Comment or question from other members of the committee? Seeing none, thank you very much for joining us today. I believe that is all of those who are signed up to testify who have shown up today. Don't stand up. And with that, I suppose we would call this hearing to a close. Thank you very much for joining us. And Representative Statstrom. Oh, I thought we said this earlier, but just to be sure, we will be here Monday and Wednesday, and you know the drill. So